case briefs, and so much more. LSData's got what you're looking for.
In 1992, a case called Farm Equipment Store Inc. v. White Farm Equipment Company focused on whether a judge could determine if a waiver or modification took place in a contract without first hearing evidence, as this job falls on the fact finder. The case revolved around a disagreement between Farm Equipment Store and White Farm Equipment Company, with Allied acting as the intermediary. The dispute arose when Farm Equipment claimed that their dealership agreement with White Farm was altered to require the return of repair components purchased from White Farm after the termination of the dealership contract. In 1986, Allied signed a dealership agreement with Farm Equipment and unexpectedly terminated it in June 1988. Following the termination, Farm Equipment attempted to return over $200,000 worth of parts, but Allied refused. Farm Equipment filed a lawsuit against Allied, alleging multiple claims and asserting that the dealership agreement had been revised to require the return of parts purchased from Allied's predecessors. However, the trial court granted partial summary judgment in favor of Allied, finding that the written dealership agreement had not been altered. Farm Equipment then appealed the decision. The Court of Appeals of Indiana affirmed the lower court's ruling, determining that the repurchase provision and annual parts return program in the contract were separate clauses. The court found that Allied's acceptance of parts from White Farm's predecessors didn't modify the repurchase provision, and the no oral modification and non-waiver provisions were enforceable.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.